So the Supreme Court issued a 5-4 order, which has huge implications for the battle between Texas and the Biden administration over the border. So let's talk about what has happened after this Supreme Court 5-4 order. Now, real quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you guys want to support this channel, if you want to help this content get out to more people, please consider subscribing to the channel. That really does help the channel to grow. It triggers the algorithm and lets it know that, hey, this information is important. It needs to get out to more people. And so again, it's something free to do if you guys want to support the channel. But regardless, thank you all so much for all of your support. As I mentioned in the intro, we need to talk about a 5-4 order that was recently issued by the Supreme Court involving the Texas border dispute and how the state of Texas believes it has a right of self-defense. Now the Biden administration is trying to take the opportunity opened up after that Supreme Court order to essentially have this entire case thrown out. The case we're going to be talking about in this video is the Department of Homeland Security versus the state of Texas. Recently, Governor Greg Abbott reacted to that Supreme Court order by issuing a letter to the Biden administration outlining that the state of Texas has a right of self-defense under Article 1, Section 10, Clause 3 of the United States Constitution. The governor makes the claim that despite what the Supreme Court said in their order, the Biden administration has failed to fulfill their duties to protect the state of Texas against an invasion, and therefore, he believes that the state of Texas is engaging in lawful self-defense and is just simply defending their residents and their state. This has set up a clash between the state of Texas and the Biden administration, along with an important legal battle that is now developing. But now the Biden administration is taking the opportunity after that Supreme Court 5-4 order to try and have this entire case thrown out to dismiss all these claims that the state of Texas is making. Now, we need to do some background on this case so you understand what that Supreme Court order was and what has now developed after this order by the Supreme Court. The recent Supreme Court order involves overruling a preliminary injunction that was granted by the Fifth Circuit 3-judge panel. And the Fifth Circuit panel's decision essentially prevented the United States Border Patrol from cutting, destroying, or otherwise interfering with concertina wire or C-wire that the state of Texas had put along 29 miles of municipal and private land in the Eagle Pass area there in Texas. Originally in the lower court case, the state of Texas requested that the court grant a temporary restraining order, which is simply a TRO. On review, the district court granted the TRO, which barred the government there, the federal government, the Biden administration, from interfering with the Texas C-wire except for medical emergencies. So that was just simply a temporary win. Texas also later sought a preliminary injunction, which would simply prevent the Border Patrol and the Biden administration from being able to cut the wire while this case is proceeding forward towards a final merits decision. In this case, the lower court granted the TRO, but then later, on review, denied the request for the preliminary injunction. Now, what was interesting about the whole lower court denial there was the fact that the judge agreed with the state of Texas on multiple issues, including the fact that the government cutting the wire, the federal government cutting the wire, was generally not necessary to prevent medical emergencies like they were claiming. The court rejected the notion that the medical emergencies could justify the destruction of the fence there, that cutting the wire would actually help to prevent medical emergencies, and that cutting the wire in one area and then leaving it open forever really wasn't justified just for one specific medical emergency. You wouldn't cut the wire for one person and then leave it open for everybody to pass into the area. But despite that, the judge denied the Texas request for a preliminary injunction. Texas then quickly appealed that denial of the preliminary injunction up to the Fifth Circuit Court of Appeals. Essentially, Texas appealed the denial up to the Fifth Circuit and then at the same time asked for the Fifth Circuit to grant a preliminary injunction, a temporary injunction, to just maintain the status quo while the appeal is taking place at the Fifth Circuit level. The Fifth Circuit ultimately granted the injunction pending the appeal. So the whole dispute that the Supreme Court reviewed here in this case isn't even on the Fifth Circuit granting a true preliminary injunction. Instead, all the hoopla in this case is over a temporary form of relief that the Fifth Circuit granted to simply maintain the status quo while they were reviewing this issue. Now, as I stated, in response to this, the federal government, the Biden administration, then sought an emergency application to the United States Supreme Court. They asked for the Supreme Court to step in early and simply vacate that Fifth Circuit injunction, which was maintaining the status quo, and they wanted that removed while this appeal is taking place. And on review, the Supreme Court issued a 5-4 order, which did in fact grant the federal government's request to vacate that administrative stay. The emergency application went to Justice Alito, who is in fact responsible for emergency applications that come out of the Fifth Circuit. The order of the Supreme Court simply stated that the application to vacate injunction presented to Justice Alito and by him referred to the court is granted. The December 19th, 2023 order of the United States Court of Appeals for the Fifth Circuit is vacated. Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would deny the application to vacate injunction. So that means that ultimately the Supreme Court voted in favor of removing the temporary injunction that the Fifth Circuit had put in place. And the two judges that jumped the line in favor of the federal government and the Biden administration were Justices Barrett and then Chief Justice Roberts. But I do again want to be clear that this is not a final merits decision by the Supreme Court. Instead, it's an emergency application, emergency review of something that was happening at the lower court level. This all involves a temporary form of relief to maintain the status quo while this case is being litigated further. But it's still not good that the Supreme Court sided with the Biden administration and overruled that injunction, effectively allowing the government to cut wire in specific areas. Now, in reaction, like I mentioned, to that Supreme Court order, the governor there, Governor Abbott in Texas, issued a letter to the Biden administration stating that the federal government and the Biden administration has failed, in fact, to enforce federal laws that would protect Texas and its residents. Therefore, under Article 1, Section 10, Clause 3, the state of Texas has what they believe is a right to self-defense, and they can still engage in this conduct. Now, after that Supreme Court 5-4 order, the Fifth Circuit Court of Appeals then responded by kicking this appeal back down to the lower court. The Fifth Circuit has now held the case here in abeyance and remanded the case back down to the lower court, the federal district court, for 60 days to essentially review and develop additional factual evidence that they believe is necessary for the Fifth Circuit to review. Recently, the federal district court held oral arguments in this case to develop that new evidence and those new records and to ultimately decide what they need to do. One of the interesting things that came out of that hearing that was issued there on remand was whether or not the district court there, the lower court, is only supposed to develop new factual records and evidence in light of what the Fifth Circuit said on their limited remand, or does the lower court there, that judge, also have the ability to issue a new judgment based on all of that new evidence? But even more concerning is the fact that the Biden administration is now taking this opportunity of the limited 60-day remand, and they're taking that opportunity to file a motion to dismiss the entire case. In their motion, the Biden administration argues that this court correctly denied Texas' motion for a preliminary injunction because the state is not likely to succeed on its claims. Consistent with that ruling, the court should now dismiss the case for a lack of jurisdiction and a failure to state a claim. Sovereign immunity bars the state of Texas and their state tort law claims. Its Administrative Procedures Act APA claims failed to challenge a final agency action, and the state has not cleared the high bar to proceed forward with this claim. Those defects and others, including the federal government's immunity under the Supremacy Clause, are fatal to the state's case. Now, this is going to be something very important to watch going forward, because the limited remand right now that's going on and the whole limited 60-day time frame is going to end very soon. But the Biden administration wants this case thrown out before that timeline. So they're taking this opportunity to now submit a new motion to the lower court saying, hey, we understand the Supreme Court issued that 5-4 order. We understand that the Fifth Circuit was reviewing this issue. They sent it back down to you for a limited time period for development of evidence. But now we're going to take this opportunity to say, despite all of that, let's throw this case out now. There's not a valid claim by the state of Texas. Dismiss this entire case for a failure to state a claim. And essentially there, the Biden administration just wants to win outright and just win here and now. Now, also keep in mind, there is a different Texas border issue, which is currently developing and is currently involving the Texas SB 4 law. That issue was recently argued also in front of a 3-judge panel in the Fifth Circuit. We're currently waiting to see what that panel will say, if they're going to grant an injunction or not. But the track record in that case is likely going to be that the panel will in fact side with the Biden administration. And I think despite what the Supreme Court's emergency interventions were, them getting involved twice in this case and it being sent back down for further development and further arguments, I think ultimately both of these cases will eventually make their way back to the Supreme Court. They're kind of destined to go back in the Supreme Court's hands very soon because this is a controversial issue. It seems like a lot of these lower courts don't necessarily want to deal with this. So I think this is an issue that's eventually going to find its way back at the Supreme Court, and maybe even on an emergency application. Once again, the Supreme Court's going to have to get involved. So that is where the Texas border lawsuits currently stand after that Supreme Court 5-4 order. Hopefully you guys found this video helpful. Hopefully it helped you understand what's currently going on with at least one of the battles currently in Texas. So if you have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.